On January 20th, 2025, the very first day of his second term, President Donald Trump signed an executive order that attempted to do something no president in American history has ever done. He tried to end birthright citizenship, the guarantee that anyone born on American soil is automatically an American citizen. That order would strip citizenship from babies born in the United States if their parents are undocumented or if their parents are here on a temporary visa, a student visa, a work visa, a tourist visa. If Trump's order goes into effect, a baby born at a hospital in New York to an H-1B software engineer from India is not an American citizen. A baby born in a hospital in Texas to an undocumented mother from Mexico is not an American citizen. A baby born in a hospital in California to a student on an F-1 visa from Nigeria is not an American citizen. According to Reuters, this order could affect up to 250,000 babies born in America every single year. Every single federal court that looked at this executive order struck it down. Every single one. The first judge to rule on it, Senior U.S. District Judge John Kokenauer in Seattle, called it blatantly unconstitutional. Other judges across the country agreed, but Trump did not stop. His administration took the case all the way to the highest court in the land. And on April 1st, 2026, just 2 days ago, the Supreme Court of the United States heard oral arguments in the case of Trump versus Barbara. The 9 most powerful judges in America sat in that courtroom for more than 2 hours debating one question: who gets to be an American? And the President of the United States was sitting right there in the courtroom watching it happen. Today I am going to tell you everything that happened inside that courtroom. I am going to explain what each justice said and what it means. I am going to break down the 14th Amendment in plain English so you understand exactly what is at stake. And I am going to tell you how this case affects you personally, whether you are a green card holder, an H-1B worker, a student, a tourist, or anyone with a family in America. But I am also going to cover 2 other massive immigration changes that just happened this week that most people missed completely because the birthright citizenship story dominated the news. One is about your social media. The other is about a form that USCIS is now rejecting as of April 1st. If you file the wrong form, your entire petition gets thrown out. Stay until the end, because the last section tells you exactly what to do right now to protect yourself and your family. Let us start with what Trump's executive order actually says. The order is called Protecting the Meaning and Value of American Citizenship. It was signed on January 20th, 2025. The order says that starting 30 days after signing, the United States will not issue citizenship documents to children born in the U.S. if one of 2 conditions applies. Condition 1. Both parents are not lawful permanent residents or citizens at the time of the child's birth. Condition 2. The mother is in the United States on a temporary visa, such as a tourist visa, a student visa, or a work visa, and the father is not a U.S. citizen or lawful permanent resident. In simple terms, if your parents do not have green cards or citizenship, and you are born on American soil, Trump's order says you are not an American. You are whatever nationality your parents are. Even though you were born in a hospital in America, even though you took your first breath on American soil. Under this order, you are not a citizen. This was immediately challenged in courts across the country: Washington State, California, New Jersey, New Hampshire. Judges everywhere blocked the order from taking effect. The order has never been enforced. Not a single baby has been denied citizenship under this order. But the legal fight has been moving through the system for over a year, and now it has reached the Supreme Court. To understand why this case matters so much, you need to understand the 14th Amendment. The 14th Amendment was ratified in 1868, 3 years after the Civil War ended. It was written for one specific reason: to overturn the Supreme Court's 1857 decision in a case called Dred Scott versus Sanford. In that case, the Supreme Court ruled that Black people, including those who were free, were not and could never be citizens of the United States. The 14th Amendment was designed to fix that injustice permanently. The key language is in Section 1. It says, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." That is it. Born in the United States. Subject to the jurisdiction. You are a citizen. For more than 150 years, this has been understood to mean virtually everyone born on American soil, with only a few narrow exceptions like children of foreign diplomats who have diplomatic immunity. In 1898, the Supreme Court heard a case that made this crystal clear. The case of Wong Kim, Arkansas. Wong Kim Ark was born in San Francisco to Chinese parents. His parents were not citizens. They were not even eligible for citizenship under the racist laws of that era. But Wong Kim Ark was born in America. When he traveled to China and tried to return, immigration officials blocked him and said he was not a citizen. The Supreme Court disagreed. In a 6-2 decision, the court ruled that Wong Kim Ark was a United States citizen by birth. Justice Horace Gray wrote that the 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory. He said the amendment was not limited by color or race and included all children here born of resident aliens. This case has been the law of the land for 128 years. No president, no Congress, no court has ever overturned it. Until now. Now let me tell you what happened inside the Supreme Court on April 1st, 2026. The government's lawyer was Solicitor General D. John Sauer. He argued that the 14th Amendment was originally meant only to give citizenship to formerly enslaved people and their children. He said that for decades after the amendment was ratified, legal experts recognized that children of temporary visitors were not citizens. He pointed to birth tourism, the practice of women traveling to America specifically to give birth so their children get U.S. citizenship, as a problem that needs to be addressed. The challengers were represented by lawyer Cecilia Wong. She argued the opposite. She said the 14th Amendment established a fixed bright-line rule for citizenship. Born in America, you're American. Simple, clear, unambiguous. And she said that rule was confirmed by the Supreme Court in Wong Kim Ark over a century ago. Now here is where it gets interesting. Let me walk you through what the individual justices said, because this tells us which way the court is leaning. Justice Neil Gorsuch pushed back against the government's argument. He pointed out that when the 14th Amendment was ratified in 1868, the United States did not have strict immigration laws. Anyone could show up and establish a home. The concept of illegal immigration, as we understand it today, did not exist. Gorsuch also pointed to the dissent in Wong Kim Ark, which said that under the majority's ruling, even the child of English visitors would be a U.S. citizen. That, Gorsuch noted, actually supports the challengers, not the government. Justice Elena Kagan challenged the government directly. She said Wong Kim Ark had a very clear rationale. There was a historical tradition of citizenship by birth. The 14th Amendment accepted that tradition, and the decision imposed no limitations based on the parents' immigration status. Chief Justice John Roberts pressed the challengers as well. He noted that the word domicile appears 20 times in the Wong Kim Ark decision. He asked why the court would mention domicile so many times if it was irrelevant to the ruling. This was an important moment because if domicile matters, then children of parents who are not domiciled in the U.S., like tourists or temporary visa holders, might not be covered. Justice Samuel Alito echoed Roberts' concern. He pointed out that the Wong Kim Ark decision begins and ends with references to the parents' domicile. Why include it, he asked, if it does not matter? But then Justice Ketanji Brown Jackson offered a fascinating explanation. She suggested that Justice Gray had emphasized domicile not because it was legally required, but because he wanted to help the public accept the outcome. Wong Kim Ark's case came during an era of intense anti-Chinese racism. By emphasizing that his parents were settled, law-abiding members of the community, Gray was making the ruling more palatable to the public. But that does not mean domicile is a legal requirement. Justice Alito agreed that this was a reasonable explanation. Justice Brett Kavanaugh delivered perhaps the most significant moment. He suggested to Wong that if the court simply accepted the challenger's reading of Wong Kim Ark, the case could be resolved with a fairly short opinion. Wong agreed. This signals that Kavanaugh may be ready to rule against the government based on existing precedent without even needing to reach the constitutional question. Kavanaugh also dismissed the government's argument about how other countries handle citizenship. He said, "We try to interpret American law with American precedent based on American history." He asked why the court should care what other countries do. Justice Sonia Sotomayor raised the most alarming concern. She pointed to historical precedent where, after the government decided that Native Americans could not become citizens, it actually went back and denaturalized people who had already been granted citizenship. She asked the government's lawyer whether Trump's order could be applied retroactively. stripping citizenship from people who were already born in America and already recognized as citizens. Sauer said the administration was only seeking to apply the order going forward, but he did not say it could not be applied retroactively. He did not close that door, and that silence may trouble the justices. Roberts also undermined the government's birth tourism argument. He asked how common birth tourism actually is. Sauer admitted that no one knows for sure. Roberts then asked whether the issue had any impact on the legal analysis. And he pointed out that birth tourism certainly was not a problem in the 1860s when the 14th Amendment was written. Sauer said, "We are living in a new world." Roberts responded with a line that will likely be quoted in every legal textbook from now on. "We may have a new world," he said, "but we have the same Constitution." Based on everything that was said, a majority of the justices appear skeptical of Trump's executive order. Gorsuch, Kagan, Sotomayor, Jackson, Kavanaugh, and likely Roberts appear to lean toward the challengers. That is potentially 6 justices out of 9. But we will not know for sure until the decision is issued, which is expected in late June or early July 2026. Now let me explain how this affects different groups of people. If you are an H-1B worker and your child was born in the United States, your child is currently a U.S. citizen under existing law. Trump's executive order has never been enforced. No baby has been denied citizenship. But if the Supreme Court were to side with the government, which based on the oral arguments appears unlikely, then future children born to H-1B holders could lose their automatic citizenship. That is the scenario everyone fears. But again, the justices appear skeptical. If you are a student on an F-1 visa and you have a child born in America, the same analysis applies. Your child is currently a citizen. The executive order has been blocked since day one. But until the Supreme Court issues a final ruling, there is legal uncertainty. That uncertainty can affect decisions about family planning, about whether to stay in America or return home to give birth. If you are a green card holder, you are not directly affected by this executive order. Green card holders are lawful permanent residents. Even under Trump's order, children born to green card holders would still be U.S. citizens. But this case matters to you because the legal theory behind the executive order is expansive. If the government can redefine who is subject to the jurisdiction of the United States for one group, future administrations could try to narrow it further. That is the slippery slope that Justice Sotomayor warned about. If you are undocumented, this case is the most critical immigration case of your lifetime. If the Supreme Court sides with Trump, your children born in America would not be U.S. citizens. They would have no legal status. They could face deportation along with you. They would lose access to federal benefits, to education programs that require citizenship, to the ability to sponsor family members in the future. Everything changes. Now let me cover the 2 other massive changes that happened this same week that most people completely missed. The first one is the social media vetting expansion. On March 30th, 2026, just 3 days ago, the State Department expanded its social media screening program to cover 14 additional visa categories. Previously, social media vetting applied to students on F, M, and J visas and to H-1B workers and H-4 dependents. Now it also applies to K-1 fiancé visas, R-1 religious worker visas, T visas for trafficking victims, U visas for crime victims, H-3 trainee visas, and several diplomatic categories. What does this mean for you? If you are applying for any of these visa categories, you must make every social media account you have publicly viewable. Facebook, Instagram, TikTok, Twitter, LinkedIn, all of them. Consular officers will review your online presence as part of the adjudication process. You must also list every social media account you have used in the past 5 years on Form DS-160, including inactive accounts, including accounts you forgot about. If you omit an account, even by accident, it can raise credibility concerns and affect your application. If your accounts are set to private during the application process, the State Department may treat that as an attempt to withhold information. The State Department has said the purpose of this screening is to identify applicants who may be inadmissible, including those who pose a threat to national security or public safety. But consular officers have broad discretion in interpreting what they find. There is no publicly available standard for what content leads to denial. A post you thought was harmless could be interpreted differently by a consular officer who does not share your cultural context. This is real. This is happening now. Clean your social media before you apply. The second change is about Form I-129. Starting April 1st, 2026, USCIS will only accept the new edition of Form I-129 dated February 27th, 26. If your employer files a petition using the old edition dated January 20th, 25, it will be automatically rejected. Not denied. Rejected. That means it is thrown out as if it was never filed. No refund of the filing fee. No grace period. No second chance. You have to start over with the correct form. Form I-129 is the form employers use to petition for non-immigrant workers including H-1B, L-1, O-1, TN, and E3 categories. The new edition includes updated fields, new compliance questions, and reflects the wage-based selection changes that went into effect on February 27th. If you are an H-1B worker and your employer is filing a petition for you right now, make sure they are using the correct form. Call your employer's immigration attorney today. Do not wait. One wrong form and your entire case is rejected. And while I am on the topic of H-1B, let me mention one more thing. The $100,000 fee. On September 19, 2025, President Trump issued a proclamation requiring employers to pay a $100,000 entry fee for new H-1B petitions for workers who are outside the United States. This fee is on top of the regular filing fees. It applies only to new petitions, not extensions, and it is being legally challenged, but it is currently in effect. If your employer is sponsoring you from abroad on an H-1B, this fee applies, and it is a significant barrier. Additionally, the H-1B selection process has changed from a random lottery to a wage-based weighted system effective February 27, 2026. Higher wage levels now get more entries in the selection process. Level 4 wages, the highest paid workers, are prioritized. Level 1 wages, the entry-level workers, are deprioritized. This means if your employer is offering you a Level 1 salary, your chances of being selected in the H-1B lottery for fiscal year 2027 are significantly lower than they were under the old random system. The Department of Labor has also proposed raising the required prevailing wages for H-1B workers by an average of 33% at Level 1. If finalized, this would be the biggest wage requirement increase in H-1B history. Now here is what you should do right now. If you or your spouse is on a temporary visa and you have a child born in the United States or you are expecting a child, save a copy of the birth certificate in a safe place. Save hospital records. Save proof of birth on U.S. soil. Until the Supreme Court issues its ruling, your child's citizenship is protected under current law. But document everything now just in case. If you are applying for any visa in the newly covered social media categories, go through every social media account you have. Make them public. Delete anything that could be misinterpreted. List every account on your DS-160 form. Even old accounts. Even accounts you barely use. Better to over-disclose than under-disclose. If your employer is filing an H-1B or any other work visa petition, confirm that they are using the new Form I-129 edition dated February 27, 26. Do not rely on your employer to know this. Send them a message today. Ask them to verify. If you are a green card holder, stay informed. This birthright citizenship case does not directly affect you today, but the legal theories being argued could affect immigration law for decades. Know your rights. Protect your family. And keep watching this channel because I will cover the Supreme Court's decision the moment it is released in late June or early July. This has been the most consequential week in immigration law in 2026. A Supreme Court hearing that could redefine who is an American. A social media vetting expansion that affects millions of visa applicants worldwide. A form rejection policy that could destroy pending H-1B petitions overnight. And a $100,000 fee that is reshaping who gets to work in America. If this video opened your eyes, hit the like button right now. It takes 1 second, and it helps this video reach more people who need to see it. Subscribe to this channel because every single day I bring you the latest updates on immigration, visas, green cards, and everything that affects your life in America. And drop a comment below. Tell me, does the birthright citizenship case affect you or your family? I want to hear your story. Share this video. Send it to every immigrant you know. Send it to every family with a baby born in America. Send it to every H-1B worker. This information is too important to keep to yourself. I will see you in the next video. Stay informed. Stay protected. And remember, the Constitution still says what it says.